Hello, ladies and gentlemen. My name is Brandon Pass, and this is my review of the Priceline User Agreement. I analyzed Part 1, Sections A through F for this presentation. This presentation will reveal my thoughts and touch on some critical points about the user agreement. To be frank, this is my first time reading the user agreement, so I took my time to make sure I understood the terminology. This user agreement states that by accessing this section of the web page, the users agrees to the terms and conditions of this user agreement. Users access this section of the web page when they make a profile, or even when they purchasing the products and services that Priceline offers. Users are required to check a box indicating that they have viewed the terms of this agreement. Let's start with Section A of this user agreement, which is the arbitration and dispute resolution. This section covers disputes against the company or entity connected to Priceline. No one can dispute an issue after 2 years of the initial incident. If there is a dispute, the user must submit a good faith statement via certified mail to Priceline. If Priceline cannot resolve the issue within 60 days, the user has a right to arbitration or small claims court suing. However, this user cannot use both avenues to resolve the dispute, nor can they combine their issue with another party's persons or third-party dispute. An arbitrator is someone commissioned by the AAA, American Arbitration Association, to handle conflicts, unlike in small claims court where a judge and possibly a jury would decide the dispute's outcome. This section was well presented and informed users how Priceline will be handling a dispute. However, 2 years is too long to wait to handle a disagreement. 6 months to a year should suffice. Bringing a dispute to Priceline should be instant. Taking 2 years to place a dispute may be a scam or attempt to get over on the company. The next section is disclaimer of warranties. This section, in so many words, talks about the products and services and the warranties associated with them. Everything sold on Priceline is sold as is, meaning there is no warranties for products and services purchased on this site. The nature of the products and services that this brand provides are for short-term use. The short-term use does not warrant a warranty. Furthermore, I saw no discrepancies within this section. General limitations of liability is a statement governing Priceline's employees, partners, parents, subsidiaries, and anyone else under the Priceline umbrella. Because Priceline is a third-party company itself, it is not responsible for the airlines, hotels, and rental agencies they broker. If there is an issue with one or more of these entities, the issue should be addressed with them and not Priceline. Priceline will, however, help resolve the issue to the limits of the law. Seeking legal action against Priceline for other companies' disputes will be directed straight to the company in question. I will not change anything about this statement. This statement was presented very accurately and concise. I have a hard time pronouncing this word. The indemnification and chargebacks informs users how the brand deals with discrepancies with cards and purchases. Priceline holds the right to investigate any chargebacks that are non-cancelable reservations, charges authorized by families or friends, supplier failure, or force majeure. Furthermore, if a user breaches this agreement, violates any laws of a third party, or uses Priceline site in a violation of this agreement, the user agrees to defend and indemnify Priceline, and all associated parties from being responsible for any damages. The last two sections are one and the same. The last two sections are one side of the same coin. The first section is trademark and copyright notice. This section informs users that all content, images, audio, and logos, etc., is under protection of the U.S. trademark law, and Priceline will pursue damages if any of its content is used without the consent of Priceline. The last section is the reverse. The last section is the reverse of the copyright notice. It is called claims of copyright infringement. If a person uses content that is trademarked and copywritten under another party, they will gladly handle this issue. However, the claimer must follow the proper steps to show ownership of the content, which is detailed within the user agreement. This agreement was a valid contract. Most importantly, it covers the brand's assets while assisting the customer and their issues. I'm glad that I read this and plan to read more user agreements to fully understand how companies I'm doing business with handles my disputes. Once again, my name is Brandon Paz, and thank you for watching.